All right, we're back on the record and recalling People v. Kurtz, file 24-93305FH for sentencing on attempted computer crime, 3.5-year maximum. I discussed with counsel in chambers the issue I had raised in response to the defense objection to a statement in the pre-sentence report. On further review with the prosecutor in chambers, it appears that I'm going to sustain the defense objection to the final sentence in the description of offense narrative. So Agent Lesky on page 3 of the CFJ 284, final sentence of the description of offense narrative, Kurtz admitted that he drove to the motel room to engage in sex with the 15-year-old female. We're just simply going to strike that sentence. That interview did contain some ambiguities, or where he did make some admissions, but also then recanted them and issued some denials. So the cleanest, I think, description is just to omit that sentence. The description of the text is in the paragraph prior to. All right, so Mr. Williams, continuing, any other defense modifications requested to factual information in the report?
No, Your Honor, we're not challenging any other factual.
Mr. Wirgo, any challenges to the factual information in the report?
Not factual, Your Honor.
The advisory guidelines were scored at 0 to 6 months. Mr. Williams, do you have any defense challenges to the scoring of those guidelines?
We would challenge offense variable 10, Your Honor. We scored at 15 points for predatory behavior. One or more of the factors described in the statute doesn't automatically equate to conduct. And in this instance, we all know that there wasn't a actual child involved in this incident. So I'm not sure. And
okay, thank you. Mr. Wirgo, your response to that objection?
Your Honor, I believe the statute reads predatory conduct. It doesn't mean to a victim actual or hypothetical. I think there's ample evidence that predatory conduct existed based off of the factual information of the PSI.
Well, the statute, MCL 777.40, subsection 3A, defines predatory conduct as pre-offense conduct directed at a victim or a law enforcement officer posing as a potential victim for the primary purpose of victimization. So, I mean, I think this would apply to a law enforcement officer posing as a potential victim, but I guess I would like to better understand the defendant. The sentencing offense is using a computer, being the smartphone, then to arrange this meetup with the law enforcement officer posing as a potential victim. To score predatory conduct, I have to find some conduct prior to that offense, pre-offense conduct. What would be on the record to establish pre-offense conduct directed toward the law enforcement, toward the victim for victimization? Mr. Wirgo?
Your Honor, I believe the PSI indicates that defendants used the website and contacted the law enforcement relative to that. Your Honor, he went hunting in essence, which is a very definition.
if I may.
Yes, Mr. Williams. It strikes me that that is the offense that he's being sentenced for, is using the computer for that purpose.
He is, and the website that he uses is an adult website, and it's not an unlawful website that doesn't target children. In fact, it has a disclaimer that you have to be 18 or older to even use the website, so it wouldn't be pre-offense conduct in those circumstances.
Where the sentencing offense is using the computer, I'm struggling to find pre-offense conduct. So therefore, I'd sustain that challenge and score OB10 at 0 points. Any other defense scoring challenges?
No, Your Honor.
Mr. Wirgo, any scoring challenges from the people?
The people would challenge the scoring of OB12 for contemporaneous felonious acts. Your Honor, we would argue that there are two contemporaneous felonious acts: use of the computer to commit the seduction, as well as the accosting. Your Honor, the plea agreement specifically says no conviction on the underlying offense, but it does reference the underlying offense of accosting for the basis of the use of the computer. Therefore, we have at least the costing as contemporaneous felonious. We would argue again that it applies is the use of a computer for the seduction as well as accosting, but at least we have the accosting, Your Honor. So we believe that it would be appropriate to score 10, at least 5. Though with the loss of the points on OV10, that doesn't shift it wouldn't shift any grades.
Mr. Williams, your response?
I don't believe that that's an accurate understanding of how the contemporaneous felonies would apply, so I would object to that.
Yeah, the computer crime is he's being sentenced for the attempted computer crime. So using the computer would be part and parcel of that sentencing offense. It wouldn't be a separate felonious act. And I understand there's some nuance to what the predicate is for purposes of SORA, with the intention to prevent Mr. Kurtz from being disqualified for any housing assistance he may need due to medical issues in the near future. But nonetheless, the allegation is that Mr. Kurtz is using the computer for the purposes of the accosting. That's what's in the plea agreement. So that's not a separate act. It's separate crimes, but it's one act. So I don't see sufficient separation, daylight between the acts. So I would deny that challenge to OV12. So that would mean the total OVs are at 0. OV level would be 1. And on this is a class E offense. So that would change the guideline range to 0 to 3 months. Is my math correct, Mr. Wergo?
Yes, Your Honor.
Mr. Williams, is my
Yes, Your
math
Honor.
correct? All right, Mr. Williams, anything you want to say on behalf of your client?
I do, Your Honor. This case has been going on for about 2 years now. Mr. Kurtz does have Alzheimer's, and I'm not going to discuss that. Parkinson's, and I know that there's other people in this courtroom that have family members that suffer with it. So I respectfully not going to say much about that. He is on 8 different medications. He has substantially declined since this case has begun. His son has been basically communicating for him and helping him figure out these complicated things that have been going on. When he got Parkinson's, he was placed on a medication that caused him to obsess about sexual thoughts. He literally scoured Indiana, Illinois, found literally hundreds, if not thousands, of people to engage in. Not all that he had sex with, but he was obsessive about this point where his wife left him and divorced him as a result of that. And as taking that medication, as his health declined, he came across this skip the games. He intended to, as he had done now, literally hundreds of times, engage in some type of form of adult prostitution. And this is where he ended up. Currently, though, he can't really drive. He can't do much for himself. And he's just a day at a time. So I'm asking the court, based off of those facts and the information in this particular case, I understand that this sting operation serves its purpose, and I do understand that I've been doing this job too for a long time, and there's tons of reprehensible, just horrible child victims in the world. I mean, it's crazy what we do as humans to each other. But Mr. Kurtz wasn't looking for a child. He wanted to engage in prostitution, as he has been, as a result of the side effect of the medication. I mean, when his whole adult life without any of these problems, he didn't seek out women, he didn't cheat on his wife, he had a successful career, and he got a disease, and the side effect of the medication disease caused his life to go in this direction. So I would ask the court, because of his medical conditions, because it's a 0 to 3 month presumptive no jail sanction, to sentence him to fines and costs. He's been going on 2 years now without any problems with the court, without any bond violations, without any charges. He hasn't been a danger to the society or the public in the pendency of this case, and we're at the end of it. So for all those reasons, I would ask the court to consider fines and costs, Your Honor. Thank you.
Thank you, Mr. Williams. Mr. Kurtz, you don't have to say anything today. If you don't, I don't hold that against you at all, but you're also allowed to make any statement. Is there anything you want to tell me today, sir, or no?
You want to say something?
Thank you, sir. Mr. Wergo, any recommendations from the people?
Your Honor, I would argue that now there's a updated record that includes hundreds of attempts to procure prostitutes, that would potentially be predatory conduct now. We didn't have that in the record before, so I'd ask the court to reconsider that. As to that, Your Honor, the recommendation, Your Honor, max him out. He came here to this county to have sex with a 15-year-old girl. Show him what happens. Thank you.
All right, well, I think the guidelines are appropriately scored on that. That wouldn't have been pre-offense conduct directed at victimizing somebody in this particular case. So Mr. Kurtz, if you please stand for the court sentence. All right, Mr. Kurtz, this is normally what to do in a case like this is pretty simple, and it's exactly what Mr. Burgo expressed. Just throw the book, bury him under the jail. There was another gentleman convicted of, well, I won't call him a gentleman, there was another adult male who was convicted of a similar offense from the same sting operation that weekend, and I sent that person to prison. So there's a very good case for me to send you to prison, lock you up in the jail for as long as I can. Each case is separate and individual. There's a lot of complicated things in this case that I don't have as clear a picture of as perhaps you and your attorney and the prosecutor do. That's not uncommon. The judge, unless we have a trial, I'm just reviewing some pre-sentence report and some materials. You all are living with the case and the facts of the case and know it in more living color than I do. Apparently, there are some documented and legitimate diagnoses of Parkinson's, which is doesn't excuse your behavior, but it is relevant to think about in terms of the length of any incarceration. And there's a documented onset of dementia, which is affecting some of your behavior. Doesn't excuse it, and nobody has filed a request for a competency or criminal responsibility. So nobody's saying you're not responsible for your conduct. So I have to sentence you for your conduct. And here he did drive to our community, knock on a hotel room door, and the text messages show that he had reason to believe there was a 15-year-old on the other side who was going to engage in sexual conduct. That's a dangerous situation. That's reprehensible conduct. The parties have reached a plea agreement in this case that avoids sex offense registration, as I understand it, principally to allow Mr. Kurtz to be placed in a home where he could receive the care that he may soon need with his dementia. So I'm not going to order SORA registration. And the guidelines are scored after the court's resolution of the challenges at 0 to 3 months. There is a defense counsel's right that there's a presumption that there would be no jail on under the criminal justice reforms for any guidelines that starts with a 0, unless the court has reasonable grounds to impose incarceration. Here, I think that there are reasonable grounds to impose incarceration, and that is the fact that you're traveling somewhere intending to have sexual relations with a minor. And I certainly hope that sounds like Mr. Kurtz's family is now placing some, as for lack of better words, some guardrails around his residency and care that hopefully are going to keep this kind of behavior at bay. He's 66 years old, has no prior criminal record or no prior indication of any concerning behavior. That's a relevant factor as well. Taking all those things into account, there are state costs of $68, the crime victims assessment of $130, court costs of $350. You have to comply with DNA testing and pay a $60 fee. I don't perceive grounds to exceed the guidelines, but I will sentence you on the top end of those guidelines to 3 months in the Prescott County Jail with credit for 3 days previously served. If you wanted to appeal from your conviction or my sentence or both, you'd have to file an application to the Court of Appeals. If you wanted a lawyer appointed, you'd have to request that within 6 months. We're going to hand you some paperwork about that appeal, ask you to initial one copy for us. The other one is for you to fill out if you wish to take an appeal. The sentence will be served forthwith. All right, that'll conclude our hearing today. Yes, Mr.
Yeah,
Williams.
just briefly, there is a, Mr. Kurtz has initialed one, returning it to the court, and he's kept one for himself.
Okay, thank you very much.
Also, he's a vehicle that was not, it was just, what asset is to be returned to him, I just made the record for it. It's taken at the time and just been sitting there since.
Well, I'm not aware of any forfeiture. Is there a forfeiture action going on with that vehicle?
We are contemplating it, Your Honor, yes.
Well, I guess deal with the prosecutor with that.
All right, thank you.
All right, we stand adjourned.
Please get this list.